In New York, all agreements for the transfer of real estate must be in writing. These are called contracts of sale. A contract of sale is a legally binding document that governs the rights and obligations of both the buyer and seller. In other words, the contract defines the terms of the transaction and the conditions under which the sale will occur. After a seller accepts a buyer's offer to purchase, it is customary for the seller's attorney to email a draft of the contract of sale to the attorney for the buyer. Before we go any further, it's important to keep in mind that, until both the buyer and seller sign the contract, neither party is bound to its terms. However, once the contract is fully signed, you cannot just walk away from the deal without risking the loss of the contract deposit unless certain contingencies are met, which we will explain in this video. While there are several different forms real estate attorneys use in the local area, all of them are filled with legal language. Whether you're buying or selling, some of the provisions in the contract may not make much sense. What's most important, however, is that you make sure the negotiated terms of the deal are accurate. These include the street address, purchase price, the amount of the contract deposit, the amount the buyer plans on borrowing, if any, the approximate closing date, personal property that will be included or excluded, and whether the seller will be obligated to make any repairs to the property. A few moments ago, we mentioned contract contingencies. The most common contingency is when a buyer is applying for a loan in order to purchase the property which will be included in the contract of sale. This contingency allows a buyer to cancel the contract and receive a refund of the deposit if the lender denies the loan application within 30 to 45 days after the contract is fully executed. In addition, the contract will obligate the seller to provide clear title to the property. Clear title involves many aspects of property that will be identified by way of a title report. Please make sure to watch our in-depth video on title reports. In the unlikely event the seller is unable to transfer clear title to the property, either the buyer or the seller may have the right to cancel the contract, at which point the buyer would be entitled to a refund of the deposit. Apart from contingencies, the contract will impose specific obligations upon the seller and the buyer. For instance, it is the seller's responsibility to make sure the property is in the same condition at closing that it was in at the time of contract, subject to reasonable wear and tear, vacant, and broom swept. Further, the contract will obligate the seller to provide a deed at closing, and, in return, the buyer must tender the balance of the purchase price less the amount of the deposit. Finally, one of the most misunderstood terms in the contract includes the closing date. Unless the contract specifically states time is of the essence, the closing date is an approximate date only. Why is the closing date not firm? Because certain conditions must be satisfied before the actual closing can be scheduled. For example, if the buyer is obtaining a loan, the closing will not be scheduled until the underwriting process is final and the lender is ready to close. That said, whether you're buying or selling, do not assume the closing will occur on the exact date in the contract. Rather, it is a target date only. On average, a contract of sale may contain anywhere from 10 to 20 pages of 10-point font and include the type of language that would put even the most severe insomniac to sleep within minutes. However, the contract of sale is an extremely important document considering the amount of money involved in typical real estate transactions in our local area. Accordingly, your team at the Donaldson Law Firm has reviewed every word of the contract to make sure it fully represents your interests as either a buyer or seller. More importantly, please do not hesitate to give us a ring or email us with any questions you may have regarding your specific contract of sale. As your attorney, we'll be happy to walk you through it.